Hey guys, and welcome to a little bit of a unique video. This is not going to be a Let's Play. This is not a top 10. This is simply a dissertation. And what am I dissertating about? I'm dissertating about the current state of Let's Playing, the laws and regulations that potentially affect Let's Playing, what the Digital Millennium Copyright Act actually does, and what fair use is and how it, applies or doesn't apply to Let's Plays. The reason I'm doing this is twofold. Number one, I just happen to think that this is a really, really good thing to talk about. I think this is something that is very interesting. Understanding some of the laws that go into effect is just fascinating. And two, to help people understand sort of where my rules come from and why I'm structured the way I am. Before I begin, I should mention that I am in no way any kind of legal authority. I'm not a lawyer. I've had no legal training. I'm just relatively intelligent. I've read the laws. So, before we really get into it, let me just cover some general concepts. First of all, what is copyright? Well, as almost every one of you know, copyright is a concept that says if you come up with an idea or you come up with a thing, other people cannot profit from that thing. It was your creation. So, George Lucas came up with Star Wars, he made Luke Skywalker, Darth Vader, and all of that, and other people can't just start releasing Darth Vader action figures to make a profit without George's permission, because that's his creation. There's a second part of that, though, and that is parody or fair use. Or fair use, which also covers parody. What fair use means is that there are instances where you can use a copyrighted idea and not be under liability for lawsuit. This most commonly comes up as an educational tool or as parody, which is why, Family Guy could do a Star Wars parody episode and didn't need permission from George Lucas. As long as you are commentating on the thing in question, parody kind of comes into effect. So, the obvious question is, well, you're commentating over a game, doesn't that make it an act of parody? Maybe? Not necessarily, but it could. There are certainly things out there which will use, what was it? There was a Lord of the Rings comic that used actual individual shots and put in their own dialogue. And it's probably an act of parody. It's one of those things, the real problem with this and what is and isn't fair use is that fair use is never explicitly defined in the law. There are some guidelines to it, but it basically comes down to the individual judge in your individual case to determine whether or not what you're doing is fair use. And the law doesn't give any specific guidelines of what is and isn't. It just says, well, as a judge, you should consider these things. So does the fact that we're making commentary and talking about the game make it an act of parody? Not necessarily, but kind of. Let's Plays are really, really legally fuzzy in this aspect. And to explain where that comes in, let me take my example one step further. If I make a book, let's say that I wrote Lord of the Rings. I'm Tolkien. I wrote Lord of the Rings. Well, needless to say, every single person that puts an elf in a book from then on out does not have to pay royalties to Tolkien. Even people that have, a setting with, several classes of wizards do not have to pay royalties to Tolkien. You cannot copyright a general plot point or an overall idea. You can only copyright very, very specific things. Hobbit is certainly something that Tolkien created. Hobbit didn't show anywhere before that, and it's a term, it can be copyrighted. Similarly, if I decided to release Lord of the Things, and I just basically re-released Lord of the Rings, only I changed the one ring to the one thing. Every instance of ring was thing. Needless to say, obviously, that is something that would violate copyright. It's very, very easy to show that it's a direct lift off of Tolkien's work. So, the reason I bring this up is because the way that copyright works in terms of books is very similar to the way it works in games. Whenever a publisher makes a game, they maintain legal control of all of the individual elements of that game. They maintain control of the sound files, the special effect noises, the character models, the movies in the game, the code that makes the game run. Just about anything that is on the CD or disc or cartridge that makes that game function is something that the publisher owns. However, they do not maintain copyright of the entire game experience. Right now, as you see in the background, I'm playing Street Fighter. Although Capcom owns everything you can physically see at any one point in the screen, the actual match is a collaborative effort between Capcom, myself, and whoever I happen to be fighting. because the match would not be happening right now without my inputs on the controller. And so I am a necessary part of the current match you are seeing. This makes any gameplay an inherently collaborative effort, and Capcom cannot claim sole right to this video that you're seeing because it's an exhibition of my own talent within the arena they have provided. So is this to say Capcom has no rights? No, absolutely not. Capcom absolutely has rights. However, claiming copyright infringement to something that is co-produced by the player is a little weird and a little wonky, and no one's quite sure how it would work. So, now that we've kind of talked about some of the big ideas, we can kind of break down and look at, fair use specifically. There are 4 sections to fair use. The first section has to deal with the nature and content of the alleged copyright. What is it that you are actually taking? In this one, this particular clause seems to come out down very, very strongly on the favor of the Let's Player and fair use. The reason I say that is because, again, because of the commentary you are adding on top of the game, that certainly makes it transformative. It makes it not a direct lift of the things they own. And again, because we just talked about, the game experience is something they don't own. So you are certainly taking all the elements they provided, but making something new out of it. And from a legal standpoint, the fact that the something new is something they planned for kind of doesn't matter. They cannot legally enforce a storyline. They can only legally enforce the segments that they provided. So when you're playing a game, even though you're playing the game they designed, that's not something that will hold up in court. It's something that you are causing to happen. Unless the game would automatically advance the storyline without your input, then as long as you are actually required in order to advance the story. As you can imagine, if I play Tale of the Abyss but I didn't touch the controller, Luke would stand in his bedroom for the entirety of the game. I'm required to make that happen. So it's not just me sharing something that belongs to Capcom, it's me sharing my play. So hopefully that makes sense. The second part of fair use kind of doesn't matter. It doesn't apply directly to games. What it really says is the nature of the copyrighted work itself. Is this a research paper and you are using its findings to advance your own claim? Is this, a segment from an Indiana Jones movie that you're just splicing in because you want to? What are we actually talking about here? Well, the thing is, we're talking about a video game. And since, again, there's a whole wobbly of who actually owns it because it's the experience, it's very, very hard to see where Section 2 comes in. The real point of the second clause is to say, hey, if you're using something for educational purposes, it's a little more protected as long as there's a legitimate reason for you to be showing it. However, when you're talking about this and the whole ownership thing is so much in doubt, Section 2 doesn't really apply to the matter at hand, so it's kind of a wash. The third point, how much of the copyrighted work are you showing? This one, at first glance, kind of seems to come down on the side of copyright infringement or on the side of the developer, because you're showing basically everything that's on the disc. But again, it's a little more complicated than that. It's a question of, you're not just making what they have available, it's through the essence of a play through, but at the same time, kind of sides on the other one, vaguely. But probably not so much that it's a slam dunk for them. But it's, again, we're kind of like the point 1 favors fair use, point 3 kind of favors the publisher, and then we come to point 4. Point 4 is really the crux of the issue. Point 4 of this, if a Let's Play ever actually came under attack for copyright infringement and went to trial, point 4 is where all of the discussion would actually be. Point 4 is, does the existence of the alleged copyright infringement negatively impact the market value of the product in question, or does it represent a actual monetary loss for the owner of the copyright? And of course, this is where both sides are going to argue different things. The publisher is going to say, well, yeah, this Let's Play came out, and a lot of my would-be customers went on the internet and saw the game being played through and decided they didn't need to buy it. Had this Let's Play not existed, they would have bought my game and played it and paid me money instead of watching it for free on the internet. Which, to be fair, is a valid argument. It's one I don't necessarily agree with, but I can certainly say that does make logical sense. That is possible. At the same time, the Let's Player is going to come right back and say, look, a game, by its very nature, is an interactive experience. A video, by its nature, is a spectator experience. It's something you cannot interact with beyond, pressing pause. Therefore, there is no competition between these two. If your game that is inherently interactive is being competed with something they can't interact with, they can't play, if that is actually negatively impacting your sales, it's not because of the Let's Play, it's because people saw your game and decided they didn't want to play it. It has nothing to do with being spoiled on the story, it's because your game was less engaging than they expected. If anything, this is becoming a marketing tool for the players so they can have an idea of what your game is like before they buy it. So it's not that the Let's Play is denying you sales because it's ruining the experience, it's letting the players know what they will be getting and letting them make informed decisions. Also, very good argument. Watching a video on YouTube is not the same as playing the game. In fact, I think the majority of you out there typically only watch Let's Plays of games you've already played. I'm sure that's not it. I have certainly watched some Let's Plays of games I haven't played, but for the most part, yeah. When I see someone playing a game I haven't played, I kind of get bored with it, because games are meant to be experienced, not watched. And very, very few games have the narrative structure to really engage you the entire way through. So, I would argue, based on my own experience, that that's a valid argument, and one that would hold up in court. But, the thing is, both arguments are valid. Both arguments I can certainly see working. And that is why I have my 6-month rule. Because the thing about the publisher's argument, that it's costing them money because people are watching it and therefore not buying it being their game, that's an argument that loses more and more credibility every minute that goes by. So I have arbitrarily decided I'm waiting 6 months to play anything. Because if I ever actually got taken to court for copyright infringement, which I really, really doubt would happen, but I plan for the worst, and they tried to use that argument, my response would be, okay, so you're telling me that you have this legion of people that wanted to play your game, but were for some reason not bothering to buy it for the first 6 months the game was out. However, they were right about to buy it, and then my video came out, and was what the tipping point that made them decide not to get it. No, but that argument is ridiculous. If you have people that want to buy it, but they don't get around to buying it within the first 6 months it's out, they probably didn't want to buy it. At least that's my argument, and I feel like that completely defangs the publisher's argument. And that's an argument I'm very willing to make within a court of law. I'm also willing to make the argument, if I made a video at launch day, I just kind of feel like, at that point, I don't know what the outcome would be. At that point, I really, really consider it both sides have a very good argument. It depends on which one the judge goes with. If I wait 6 months, then the argument the publisher has really is untenable. It relies on a huge statement of faith that there's no possible way that could be proven. And it's just logically does not follow. So, that is where my 6-month rule comes from, and that's some of the logic and the reasoning behind what I learned when I did have to fight this when my Persona 4 Arena videos came out. Lastly, before I go, I would like to briefly talk about kind of why this is also gray and in the air and why no one really knows what would happen. The way that the law works, unfortunately, is that whenever there's a bit of confusion in the law and no one's quite sure what would happen, we just have to let a court case go through the court system and see what is actually ruled. The body of law is sort of built on previous rulings until a ruling comes along that affects or overrules a previous one. The thing is, though, the presence of Let's Plays and whether they're copyright infringement is an issue that has never come up in the court system. No one has ever tried to sue over the existence of a Let's Play. And the reason for that, largely, is because of another law that exists. When the Digital Millennium Copyright Act came out, it put a lot of more safeguards and a lot more things into the system that were now illegal. It did this because, obviously, the digital media were becoming much more prevalent, and the old copyright law just did not handle this new form of distribution. However, it specifically said that nothing in the Digital Millennium Copyright Act was meant to redefine or alter the fundamental way in which fair use was interpreted or the rights and protected things under fair use. Additionally, it made a specific requirement that any person that was claiming copyright infringement under the Digital Millennium Copyright Act was required to check and ensure that the copyright, the alleged infringement was not something that would be protected by fair use. It did this primarily because, as you've seen on YouTube, Whenever the supposed victim makes the copyright claim, YouTube responds by immediately taking the video down. It doesn't have to go through the court system, and this was because the court system was so backlogged. The system did not want a basically unwinnable game of whack-a-mole going on, where the legitimate copyright holder was having to wait months to get the illegal information off the internet. So they said, okay, you make the claim and we'll deal with it immediately. However, if you make a claim against fair use and you're later found that you knew it was fair use and you did it anyway, there can be penalties. If something is legitimate under fair use, you should not be trying to take it down. And that's why this has never come up in a court of law. Because as long as there's never been a court case about it, publishers can legitimately say, oh, well, we considered this wasn't protected by fair use. It's never come up, so we didn't know, but it certainly didn't seem like fair use to us. And you can't disprove that. Since it has never come up, I happen to think it's covered by fair use, but I don't know. It's an issue that has not been resolved. However, the second a company actually brings this to a court of law, to a judge, they're putting a huge amount of their chips in the middle. Because if the judge deems it is fair use, then instantly they cannot make any further copyright claims against any Let's Play video out there. Or they become liable for violating that clause of the Digital Millennium Copyright Act. Once there is a precedent for it being fair use, if they try and get it taken down, then not only will theoretically not get taken down, but they can be countersued. Right now they can't. So, that's why a number of people, when their video gets taken down, I think a lot of YouTube will simply shut up about it and let it be taken down and just kind of go and hide because they don't want to get sued. I won't, because I know how the law works, and I know that as long as you put in a properly worded, counter-argument and explain why it's fair use, then the publisher has 2 weeks to respond, and their only viable responses are to either take you to court or let it be put back up. I obviously have made that response. They let the video go back up onto the internet because there's no way they want to risk getting this actually ruled on by a court system. So, a little bit of an interesting back and forth. This is why videos are the way they are. This is why a lot of times with any established publishers or any established Let's Players, their videos will go down for about 2 weeks and then they'll pop right back up. So hopefully that was informative. Hopefully that was interesting. If not, I'm sorry. If so, awesome. Join me Monday when I start Tales of Grace's F.